morning. Thank you all for being here for the 24th IRC Rothgerber conference hosted by the Byron White Center. As you all know, this conference today is honoring our colleague, Bob Nagel, who will be retiring this year after a really remarkable career that has influenced not only the development of constitutional theory, but also the development of many law students. It's particularly fun for me to see how many former law students are here in the room because of the impact that Bob had on their lives and continues to have on their lives. I think that's a really wonderful tribute to him. I also want to say, as the current director of the Byron White Center, I'm Melissa Hart. I'm the current director of the Byron White Center. Bob was a longtime director of the White Center, and Paul Campos, who's on today's first panel, was actually the first director of the Byron White Center. So there's a lot of White Center history here today. I'm going to turn things over to the moderator of our first panel, Justice Allison Ide of the Colorado Supreme Court, also once a colleague, and let her kick things off. So, Allison.
Well, thank you. Thanks everyone for being here on this beautiful Colorado morning. I know you're all racing down to the Rockies home opener here in a bit, so we'll get our constitutional law discussion underway. I want to thank Melissa, Professor Hart, for putting this illustrious panel together and this whole program celebrating the work of Bob Nagel. Also thanking the Law Review. I know I was in your shoes. I know it's a lot of work to put this together, so thank you. I just want to take a moment to personally thank Bob for everything he has done for me. I know, I'm starting to tear up. Seriously, I arrived here at the law school the fall of 1998, and Bob and his wife, crew, welcomed me with open arms, really took me under their wing. Bob always had an open door policy, and I took advantage of it. Always in his office talking about ideas or my classes or whatever. He was such a good friend and colleague. And during that time, actually, he was working on his book and publishing his book, Implosion of American Federalism. And that was a really exciting time for me because I, too, wanted to write in the area of federalism, not at the level of Bob, but it was amazing to have him as a resource. And in preparation for this panel this morning, I actually pulled my copy and opened it up, and I just wanted to read the inscription. To Allison, a good friend and colleague, stay cheerful despite what I say in this book. So as you can see from that inscription, he was a bit more pessimistic about federalism than I was. I was the optimist there. But in answer to your question, Bob, I have stayed cheerful and optimistic despite the book. But I have to say that just everything he says in there and everything we talked about really challenged my assumptions about American federalism, really made me think more deeply and critically about the topic. And I know each person here in this room, you've had that experience with Bob challenging you and your ideas. So thank you, Bob. We're going to turn to my illustrious panel here. This is just such a privilege and honor to introduce this group. I actually printed out their CVs and went through a ream of paper. I can tell you this group here has produced a mountain, literally a mountain of scholarship, and it's just so impressive. I want to start with Larry Alexander. He's the Warren Distinguished Professor of Law at the University of San Diego. He's been there since 1970.
I started when I was 12.
Exactly right. He is a graduate of Williams and Yale and is widely published in the area of constitutional law, criminal law, and jurisprudence. Then we're going to turn to Mark Tushnet, the William Nelson Cromwell Professor of Law at Harvard. Went to Harvard undergrad and Yale Law School for Justice Thurgood Marshall, and is widely written in the area of civil rights, constitutional law, and comparative constitutional law. And I have to say, while I'm here, I pulled his book, which I used in my comparative constitutional law class, and there's no inscription. So I am going to get that taken care of today. Okay. Excellent. Finally, we have Paul Campos from here at the University of Colorado, also a former colleague and a great friend and colleague of mine. He attended Michigan and teaches and writes in property and constitutional law and legislation. But really, as you can see today, is a commentator on American life and culture, and most recently wrote a book about why you should think twice before you go to law school. For all of you law students here, that's too late for you. But that's just an example of what he's interested in. I think we are going to proceed with Professor Alexander going first today, followed by Professor Tushnet and Professor Campos. And actually, just one more thing. Bob said, "Ha, you're a moderator of this group." We are just going to proceed in that order, and I think have a free-for-all. So.
No, thank you. I hope you can hear me. I've been fighting laryngitis, and so I'll try to do this without amplification. So when I was invited here, and I want to say what a privilege it is to be here. I've known Bob for a long time, and I'm jealous of his view here. So I went back and pulled an article of Bob's, and that's going to be the basis of what I have written. And so if you will excuse the fact that I'm going to read something to you, I just feel more comfortable once I've written it out to express it that way. I think I'll get this across better. So I titled this, Bob Nagel and the Emptiness of Supreme Court Standards of Review. Bob Nagel is a well-known and persistent critic of Supreme Court decision-making, and in particular the court's stated formulae for how those decisions were reached. Bob's neologism, the formulaic constitution, was not coined to be an honorific term. For Bob, the court's announced rationales often seem hollow and thus quite manipulable, disguising whatever might have been the court's real reasons for reaching a decision, and perhaps even blinding the court itself to those reasons. Those of us who are unfortunately tapped by our deans to teach constitutional law to law students who quite rightly expect a payoff of doctrines that are reasonably coherent, feel doomed to disappoint. For in most areas of constitutional law, doctrine as such is absent, and what exists in its place is one damn case after another, often with shifting 5-4 lineups of justices. Perhaps each justice is consistent, though I doubt it, but the 9-justice ensemble, with each of the 9 eventually replaced by someone with a different view of the cathedral, is surely not consistent. Thus, in most areas of constitutional law, so-called, a lawyer who cannot find Supreme Court decisions that support her side of the case ought to be disbarred for incompetence, as should a lawyer who cannot see that there are Supreme Court precedents supporting the other side. So instead of teaching law students a body of doctrine, we constitutional law teachers are forced into teaching one can argue this and cite that, and one could argue the opposite and cite that. Law is a normative discipline, but that is about as normative as we constitutional law teachers can get and still tell the truth. We could, of course, discuss the original meaning of the constitutional provisions, which might be useful if the court paid any attention to the Constitution's meaning. Or we could mimic the social scientists and try to be predictive, which is useful in advising clients, perhaps, but of no use when you must make normative arguments to a court. Bob saw early on, just how early I'll get to momentarily, that the court's constitutional standards of review were quite arid and manipulable formulas that did no work and could do no work in deciding cases, but that disguised whatever actual grounds for decision were consequential. Has the court ever really told us what governmental purposes described at what level of abstractness are legitimate or important or compelling? Indeed, has it ever told us from where in the Constitution or its context such a hierarchy of government purpose is derived? Those questions are, of course, rhetorical. The answers are no and no. As I said, Bob solved all this early on, as a law student, no less. When I began teaching law in 1970, I had a subscription to the Yale Law Journal, perhaps because I was a Yale Law product, or likely because I imagined a few prestige law journals would be sources of much needed wisdom, a view from which I was eventually weaned. In any event, as I was teaching constitutional law, I read all the constitutional law articles in those journals, including the student notes. And although the articles seldom provided the wisdom I sought, one student note did. The note was titled Legislative Purpose, Rationality, and Equal Protection, and its author was one Robert Nagel, Yale Law student. Bob's note, which I recommend to all of you, is brilliant. I would place it alongside Anthony Amsterdam's justly famous note on the void for vagueness doctrine as maybe the best student note ever published. Indeed, I think Bob's note is even better than Amsterdam's. Bob's note's target is the court's rational basis review. The cases he analyzed may be unfamiliar to many of you. After all, the note was published in 1972, almost 2 generations ago. Still, Bob gives you all the facts and opinion passages you need to get his point. And that point is that rational basis review cannot do the work the court claims it does. In a nutshell, when a statute's non-suspect or non-semi-suspect classification is challenged as violative of equal protection, the statute will be upheld if, but only if, the classification is, quote, rationally related to the legitimate purpose or purposes the classification is meant to serve. That is rational basis review, or so the court says. Bob begins his analysis of rational basis review by taking up the court's then recent decision in Eisenstadt versus Baird, a case that I suspect most of you who teach constitutional law are familiar with, no matter your age. Recall that in that case, the court struck down a Massachusetts statute that made it a crime to dispense contraceptives to unmarried persons for the purpose of preventing pregnancy. The statute permitted married persons to get contraceptives for that purpose, so the equal protection question was whether distinguishing unmarried from married persons in that context served a legitimate state purpose. And the court's answer was that it did not. As Bob pointed out, the court reached this result by a divide and conquer method. It took up a series of possible purposes one by one and purported to show that none could support the differential treatment of the married and unmarried. The court first took up the purpose of discouraging premarital sex, but found that because unmarried persons could get contraceptives to prevent disease, and married persons could use contraceptives to have sex with the unmarried, the prohibition of unmarried persons getting contraceptives to prevent pregnancy would have only a minimal effect on achieving this goal. The court then took up a second possible purpose, that of regulating the distribution of potentially harmful contraceptives by requiring them to be prescribed by physicians. But as the court noted, the protective function of physician control applies equally to the unmarried and the married, and so cannot support the state's differential treatment. The third possible purpose was that of preventing the use of contraceptives, but because the statute did not prevent married people from using contraceptives, that purpose was obviously not served. Here is Bob's critique of the Eisenstadt court's rational basis analysis, and now I'm quoting Bob's note. The divide and conquer analytical tactic also permitted a convenient simplification of each purpose, where it is only in the context of the full statutory scheme that full meaning can be given to each legislative objective. For example, when the plurality opinion discussed the third objective, preventing the general use of contraceptives, it asserted that that evil, as perceived by the state, was identical as between the use of contraceptives by married and by unmarried and married people. The plurality could then argue that exemption of married people from the prohibition against obtaining a prescription was not rational. Where contraception is itself an evil, is it not an evil as evil for married as for unmarried persons? But if the legislation was also designed to discourage premarital sexual activity, the use of contraceptives persons manifestly is not the same evil as is their use by married persons. These illustrations show that if the plurality had defined the overall legislative purpose as consisting of the partial achievement of several sub-purposes, the determination that the statute was not rational would not have been so easy. The legislature's overall purpose might have been defined as follows: to discourage premarital sex by making contraceptives harder to obtain to the extent that this would not increase the risk of venereal disease, to provide for the medical supervision of the distribution of contraceptives to the extent that this would not increase the availability of contraceptives to the unmarried, and to discourage the use of contraceptives to the extent that this would not interfere with the private behavior of married persons. Unless it is irrational per se for the legislature to design a statute to achieve a set of somewhat conflicting policy objectives, the Massachusetts statute would appear to have been rational. That's quoting from Bob's piece. Bob argues convincingly that rational basis review is, as he puts it, invariably an empty requirement and a misleading analytic device. Or he points out, it is always possible to define the legislative purpose of a statute in such a way that the statutory classification is rationally related to it. But when a class is benefited or burdened by a statute, the statute's purpose can be deemed to be to benefit or burden the trait that defines the class. Indeed, just as the court in Eisenstadt disaggregated a possible mix of purposes and found each one wanting, when it wishes to uphold a statute, it can aggregate distinct purposes and find that, for law, the statute serves the mix perfectly. A couple of cases illustrate this method. Magoon versus Illinois Trust and Savings Bank dealt with an inheritance tax, the rate of which varied among blood relatives according to how closely they were related to the decedent, and among unrelated legatees according to the amounts of their bequests. The purpose to be derived from this scheme, Bob states as follows: the purpose is to reduce the transfer of wealth through inheritance, but to do so to the extent compatible with encouraging intra-family support. And the statutory scheme fits this purpose, which is really a mix of purposes, like a glove. It fits tautologically, for the purpose or mix of purposes is derived from the statutory classifications themselves. Bob illustrates this tautological use of the rational basis test by comparing the majority and dissenting opinions in Levy versus Louisiana. The statute in Levy gave legitimate but not illegitimate children the right to sue for the wrongful death of their mother. Justice Douglas looked at only one purpose, that of compensating children for the loss of their mother, and could see no reason to distinguish illegitimate from legitimate children for that purpose. But Justice Harlan noted another purpose, that of discouraging non-marital procreative relationships. That suggests that the purpose of the statute could be construed to be compensating children for the loss of their mother to the extent that compensation does not legitimize non-marital relationships. One more case that is illustrative is another fairly old but probably quite familiar one, Railway Express Agency versus New York. There, New York City had a traffic regulation that banned advertisements on the sides of motor vehicles, but exempted ads for the business of the vehicle's owners. Railway Express Agency, which made a lot of money from carrying ads, usually for cigarette brands, on the side of its fleet of trucks, claimed the exemption of owner ads violated equal protection. If the purpose of the ban of REA's ads was to promote traffic safety by reducing driver and pedestrian distractions, then were not the owner ads equally distracting and disserving of the purpose? The court surmised that the legislature had concluded that owner ads were less distracting, but that seems quite far-fetched. Has anyone observed pest control vans recently with their large rat or termite figures on the roofs? The more accurate statement of the purpose, according to Bob, is that it is to promote traffic safety slightly by reducing the number of distractions without jeopardizing the businesses who advertise on the sides of their own trucks. And I would add, to do so without jeopardizing those merchants who have fixed signs at their places of business, or the billboard industry and those who advertise on billboards. Stated thusly, the statute served its mix of purposes quite well. Although Bob doesn't mention it in his note, another purpose that when added to the mix makes statutes classification schemes rational is that of administrative convenience. Blunt rules, although frequently under-inclusive with respect to their primary purposes, are much easier to administer than more flexible standards or more complex rules. For example, in Beezer versus New York City Transit Authority, a case decided many years after Bob's note, the New York City Transit Authority banned methadone users from all jobs. The primary purpose was transportation safety, which former addicts might imperil if given certain jobs, but many jobs in the authority were not of that type. Still, the court upheld the ban for all jobs, in part because the blunt rule was easier to administer. Now, one way to avoid having the rational basis test become tautological, and thus empty and useless, is to deem some purposes illegitimate. The court, however, has never told us what makes purposes other than a desire to harm a group illegitimate. Indeed, even that desire cannot always be illegitimate, and the legislature not desire to harm murderers and rapists. Are there any other illegitimate purposes, and if so, why are they illegitimate? And just where in the Constitution can one find the basis for calling some purposes legitimate or illegitimate? Aside from deeming a purpose illegitimate, what other methods does the court employ to avoid deeming classifications rationally related? Bob lists three: ignoring a purpose, stating the purpose as singular rather than a mix, and manipulating the level of abstraction at which the purpose is stated. Bob gives several examples of the first two, including the cases previously mentioned. So let us look at the third, the manipulation of the level of abstraction. In Gulf, Colorado and Santa Fe Railway versus Ellis, a statute permitted successful tort claimants to recover attorney's fees if they had sued a railroad corporation. The court held that the statute failed the rational basis test, but did so by focusing on purposes characterized sufficiently generally that the statutory distinctions failed to serve those purposes. As Bob put it, the evils the statute might have been aimed at can be stated in the following order of descending generality. 1, to decrease the likelihood that any tortfeasor will escape his obligation to repay his victim. 2, to decrease the likelihood that any corporation might abuse the privilege of existence afforded it by the state by escaping the obligation to repay tort victims. 3, to decrease the likelihood that any business corporation will abuse the privilege of carrying on business activities that the state affords it by escaping its obligation to repay tort victims. 4, to decrease the likelihood that any quasi-public commercial corporation will abuse its special function by escaping its obligation to repay tort victims. 5, to decrease the likelihood that railroad corporations, which have a tendency to resist the demand of tort claimants, will escape their obligation to repay their victims. The court's conclusion that the statutory classification was under-inclusive followed inevitably from the level of generality at which it defined the evil at which the statute was thought to be aimed. The court argued that the statute might have been intended to deal with problems as broad as 1 and as narrow as 4. Of course, if the court had acknowledged the fifth purpose, a conclusion that the statute was rationally related to the purpose would have followed. The terms of the statute plainly suggest that the court had defined statutory purposes too broadly. Although there's much more in Bob's note than I have discussed, I think I've adequately conveyed the strength, indeed the brilliance, of its critique of the rational basis test. It is hard to believe that Bob was only a law student at the time, but it is easy to see from Bob's later work that the boy was the father of the man. Thank you.
Thank you. I want to thank Justice Ide for the introduction and note that for years I have attributed to her, perhaps wrongly, the burden of my current research project. I believe, it could be mistaken, that she was a member of the Oliver Wendell Holmes Devise Commission of the United States when it assigned me, like 10 years ago the job of working on the volume on the Hughes court in the 1930s, which turned out to be modestly relevant to something I'll say later. I've been working on that project for a long time. I see the end in sight, I think. So less resentful than I used to be. But in any event, I'm also going to talk about Bob's student note. My wife cautioned me against saying that it was the best work of his career. For obvious reasons. So I'll sort of echo Larry's concluding observation that it foreshadowed a distinguished career. And I'm going to talk a bit about, or I'm going to bring a bit of comparative constitutional perspective to this, although the points that I will make are in Bob's work itself. I too am going to focus on the problem which, once stated, seems sort of obvious, which is the sign of really brilliant work, which is statutes have multiple purposes. And what legislatures try to do is either jointly maximize, or which is the way the presentation of the Nagel case is given in the article and by Larry, or in more contemporary, again, continental constitutional theoretical terms, jointly optimize the multiple purposes. That optimization is a term used by the German constitutional theorist Robert Alexis. So once you see that, the idea that there could be irrational classifications becomes quite problematic. And I'm going to talk about one of the techniques that courts have used once they realize this difficulty, which is to rule out certain, not quite purposes, but certain ways of doing things as impermissible. So the first one is one that Larry also mentioned, which is the problem of administrative costs. Legislatures adopt rough classifications. They are challenged on the ground that you could accomplish the rough classifications to accomplish admittedly narrow goals, or well-defined goals, such as the visa exclusion for methadone users. They acknowledge that these are rough classifications, but they say we're using them because achieving greater precision, while possible, will be more costly. So we, in the visa case, we would have to have individualized hearings or more detailed inquiry into whether the person would be a safe operator of the subways. Now, when this issue eventually, courts around the world sort of recognized the problem of administrative costs in connection with programs that classify only roughly. And they tend to say, we understand what's going on here, but we don't think that it is constitutionally permissible to restrict a right, which is how they conceptualize it. I am getting over a cold. I hope. We don't think it's constitutionally permissible to restrict a right merely to save administrative costs. And so, yes, we understand what you're doing, but this is a goal that is ruled out, and then once we rule it out, what you've done is burden a right in an unjustifiable way because the justification you've offered is one that you're not allowed to offer. The cases I'm thinking of where they explicitly talk about administrative costs are some cases from the Canadian Supreme Court. And then along comes a government, these are in Canada, they're provisional governments, and other countries, they're national governments, that explicitly adopt austerity programs. And they say, we're going to cut a bunch of things for the purpose of saving money. Well, in the course of doing that, they adopt classifications. Some cuts are larger than others in different classifications, so on. And these are challenged as the classifications are challenged on the ground that they identify a certain category of activity for a budget cut, but the activity is not related to the cut. And once the courts are hit over the head with that, again, where the purpose of the classification is to save money, they say, oh, I guess that's right. You can take administrative costs into account. As far as I know, that hasn't led them to circle back around on their earlier decisions, but at least they understand the nature of the problem. I'll come back in my conclusion to why ignoring administrative costs has seemed attractive. The second impermissible technique is what I think of as the interest group carve-out. So in Bob's note, he talks about a case called Smith against Cahoon, which was decided in 1931, where, to simplify, there's a carve-out from a regulatory scheme for agricultural products. And the straightforward explanation for that is that it's an effort to satisfy the interest group demands of the agricultural industry. My current favorite comparative example is a German case in which the legislature imposed a ban on smoking in restaurants and bars and discotheques, and then said, but if you are a restaurant or a bar, you can have a separate room in which smoking is allowed. This was challenged by discotheque operators on the ground that they weren't allowed to have a separate room for smoking. And the German Constitutional Court said, yes, this was unconstitutional. The carve-out for restaurants and bars was unconstitutionally discriminatory against discotheques. Again, there too, the explanation is pretty straightforward. The restaurant and bar industry lobbied for and obtained this exemption, which the discotheque industry was not powerful enough to obtain for itself. So how do you understand a case like Smith and Cahoon or the discotheque case? Well, one way to understand it is to say that mere interest group carve-outs, pluralist bargaining, embedded in statutes, is constitutionally impermissible. And that's not in itself, you might think, and that's sort of desirable, because what it does is encourage or constitutionalize the idea that legislation should be the product of deliberation rather than mere interest group bargaining. And the idea that legislature should deliberate is not an unattractive idea. The difficulty is once you say there's this problem with interest group bargaining in the legislative process, you have to figure out what the scope of the constitutional concern would be. And that turns out to be extremely difficult, an extremely difficult question to answer. So just one way of saying it is there's in the U.S. a division among the courts of appeal on the question of whether a legislature can defend an economic regulation against an economic due process challenge on the ground that it is protectionist, merely protectionist. We want to subsidize or provide competitive advantages to particular segment of industry. Some courts of appeals say that's not a permissible legislative goal. Others say it is. Well, this mere protectionism just is interest group legislation. Even worse, there are solutions to what I'm about to say, but they're very complicated and tricky. What about situations where you observe trade-offs across statutes? So in the Smith and Cahoon example, the agriculture industry says you have this important education program, clearly a good public interest legislation. You need votes to get it passed. We will vote for it, but only if you give us this exemption from the regulation in Smith and Cahoon. If you prohibit that kind of trade-off across legislation, you may actually reduce the level of, just call it public interest or public welfare regarding laws. Again, there are ways to deal with that, but they are complicated. And my final observation on this point about privileged bargaining is that the permissibility of the constitutional permissibility of interest group bargaining may depend on how either the constitutional court or more generally the legal culture understands the national political culture. And so it might well be, I take no position on this because I really don't know enough, that in the United States, ruling out interest group bargaining as a permissible goal would be undesirable because we have a deep commitment to pluralist political processes, whereas in Germany or this presentation in connection with the Israeli Supreme Court in Israel or in Canada, it might be that they have a constitutional commitment to a more fully deliberated process than in the United States, or treat interest group bargaining as normatively exceptional rather than characteristic of the process as a whole. And so just the bottom line here is that while the impermissible goals part of response to the difficulty that Bob identified might be problematic in the United States, it might be for reasons of political culture acceptable elsewhere. My final observations are about, return explicitly to the United States, which is why do courts in the United States seem to evade the implications of the joint maximization idea that Bob identified? Why is evasion so attractive? And here, this may foreshadow some things that folks may say. My take on this is that it's attractive because by saying legislation is irrational, you are able to avoid or conceal the fact, you meaning a judge, are able to avoid or conceal the fact that what's going on here is actually more or less straightforward judicial value choices about what is good legislation and what is not good legislation. The last line of Bob's note is, however actively it's used in the future, referring to something earlier, the process of forthright constitutional adjudication would be well served if courts would recognize that discussion of a statute's rationality is a meaningless and confusing exercise. What that opens up is the question of what is forthright constitutional adjudication. And there are a number of answers that could be offered to that. This is the last line of the explain what forthright constitutional adjudication is. Thank you.
All right, the first things I say are not going to be meaningful, which is Larry has to get some coffee. What I was asked to participate in this panel, I'm of course very honored, and tried to come up with what I thought would be a particularly interesting and unanticipated subject to discuss. And so what I came up with was a Bob student note. That didn't work out so well. So I'm going to have to vary a little bit what I was planning to say, except to simply emphasize my agreement with the evaluations that Larry and Mark have given about its quality and its accuracy. I think that when Allison mentioned that Bob had described her book saying, you should be more cheerful than this book might lead you to otherwise be, he was pointing to something quite real, which is that there's something actually quite dismal about spending your life analyzing constitutional doctrine. And it really is. I'm not being facetious. It's similar to, imagine if you were a book reviewer who could only review Harlequin romances, or a movie reviewer who could only review Jerry Bruckheimer movies. What would your reviews consist of? They would consist of saying, well, I'll quote Orwell here on book reviews, actually. He says, it is almost impossible to mention books in bulk without grossly overpraising the great majority of them. Until one has some kind of professional relationship with books, one does not discover how bad the majority of them are. In much more than 9 cases out of 10, the only objectively truthful criticism would be, this book is worthless, while the truth about the reviewer's own reaction would probably be, this book does not interest me in any way, and I would not write about it unless I was being paid to. The public are not paid to read that kind of thing. Why should they? They want some kind of guide to books they are asked to read, and they want some kind of evaluation. This refers back, of course, to some points Larry made about the problem of teaching constitutional law, right? Students who naturally expect that for the increasingly large sums that they're being asked to fork over, they should be getting something out of it. But as soon as values are mentioned, standards collapse. And I've updated the references here slightly. For if one says, and nearly every reviewer says this kind of thing at least once a week, that King Lear is a good play and Keeping Up with the Kardashians is a good television show, what meaning is there in the word good? So, this I think is a problem that faces us in the legal academy. And I think it's by far not limited to constitutional law, but constitutional law is, I think, a place where it's particularly stark, which is that we essentially have to treat things that are one thing as if they are another thing, because those things themselves present themselves as being something when in fact they are something else. So here, Mark's correct that I would emphasize the point that when the Supreme Court is presenting its jurisprudential insights as a kind of exercise in political theory or philosophical analysis or ethical interpretation, it's not really doing that. Nor is it, in fact, engaging in anything that would, I think, traditionally be considered doctrinal analysis, because, as Larry mentioned as well, the doctrine is just this contradictory mess that can basically justify just about anything. So what is it doing? Well, it's doing something quite different. What it's doing is, as Mark mentioned, that I would say, what it's doing is it's doing politics, very straightforwardly. So, for example, when you have the rational basis test, and it says, that a piece of legislation has to have, a a rational relation to a legitimate government interest, obviously everything in that formula turns on the concept of legitimacy. But the concept of legitimacy is not something that lawyers or judges have any particular insight into, nor is it something that legal doctrine offers any aid in being able to figure out. It's a purely political judgment all the way down. And in this way, I think it's interesting that I think Bob's work has always been what I think of as a kind of culturally conservative critical legal studies. You know, that he's basically making many of the fundamental insights and points about that are associated with the critical legal studies movement from a somewhat heterodox political position, because most of the critics, of course, are sort of self-consciously leftist. But he's the politics here of whether left or right are, I think, relatively unimportant. What's important instead is the intellectual and cultural critique, and it is, in one sense, Bob's note is very much a tour de force, but in another sense, it's just depressing as hell, right? Because you have this 24-year-old law student who's basically laying out this a bunch of garbage, basically, and he's right. So, at that point, you kind of wonder, like, well, where do I go from here? And I don't have a good answer to that question. Mark was asking, I think, something along those lines. He was asking, well, what else are you going to do other than pretend that you're doing something other than what you're doing? Now, if you're a judge, this seems to me to be a kind of, perhaps a kind of professional quandary or conundrum or deformation, that this is just what it is to be a judge. You have to talk in a certain kind of way, which is often quite empty. But that's part of the job. It's a dirty job. Somebody has to do it. Okay, fine. But it seems to me that there's and I don't want to exaggerate, but I do think there's an almost kind of tragic quality to the legal academic who spends his or her life essentially aping the role of the judge when the academic is under no professional obligation to do that, right? I mean, so much of our careers often get spent engaged in this kind of pseudo judicial behavior or activity or rhetoric when we are not only are we not obligated to be deciding cases, we're not deciding cases, and no one is paying any attention to what we're saying about deciding cases, essentially, and yet we still engage in this kind of empty intellectual enterprise of pretending to do one thing when we're actually doing another. I mean, obviously I'm drawing broad generalizations here, but that, I think, is a kind of a tragic condition, right? Because we don't have any authority, right? And yet we spend our lives acting as if we do and talking as if we do. And that is, I think, potentially quite demoralizing and dispiriting. Here, I'll give you a couple examples of just how, I don't read Supreme Court opinions because I literally cannot bear doing so. So unless there's like some kind of court order that requires me, but like every time I start reading, when I get like 2 sentences in, I go, okay, I can't do this anymore. And I'll show you how bad this stuff. Essentially, you can take any oracular statement of the Supreme Court and just rephrase it to say exactly the opposite, and nothing changes. In other words, it's just as plausible or implausible, as the case may be. I'll give you a couple of quickie examples. This is the first sentence of the joint plurality opinion in Casey versus Planned Parenthood, abortion case from 1995. Liberty finds no refuge in the jurisprudence of doubt. Okay, that sounds vaguely plausible. Not sure what that means, but oh, watch this. Don't try this at home. Especially for professionals. Liberty finds no refuge in a jurisprudence of dogmatism. Sounds plausible, kind of sort of oracularly interesting as well. Well, how about the first sentence of Obergefell, the gay marriage case? The Constitution promises liberty to all within its reach. Okay, yeah, sounds good. I'd like some of that. The Constitution does not promise liberty to all within its reach, but it's actually a somewhat more plausible statement. And so then what we end up with is a situation where we have to treat with a sort of kind of seriousness and maybe with a certain degree of respectfulness a bunch of stuff that really should be understood in other terms. In other words, when you're looking at Supreme Court opinions and looking at, law firms love to do this. We love to rework the Supreme Court opinions so that, like, they make more sense, supposedly, and they maybe they reflect, Rawlsian political principles, or, maybe even to me, the most outrageous move is the sort of law and literature one of, like, trying to treat judicial opinions as, like, having, like, all kinds of aesthetic value, that they're really kind of great literature or something. I mean, I think you have to be kind of high on your own supply to basically. But the law and literature crowd sort of made a career out of doing that. I wouldn't name any names, you might be able to think of some yourselves. Anyway, you're in a circumstance where you have to recharacterize stuff to have virtues that it doesn't have. To treat Supreme Court opinions, which are they're bureaucratic work products that are engaged in mystification for the purposes of advancing certain political goals. I think didn't you say that sometime? I think Mark, that's what the critics said that, right? And they were right. They were absolutely right. Bob said it when he was, 17 years old. He was right. He's absolutely right. That's what they are. That's what they do. And if you spend your life trying to make constitutional doctrine something other than that, you're going to lose, because it's going to win. It will destroy you. It's like a kind of Terminator. Remember, I'd say one of the things that happens when you get older is, I'm sure my more senior colleagues here have had this experience even more plangently than I have, which is you don't know what references your students have anymore, right? It's like cultural references. Like basically, the only things I can count on now are like Star Wars and the Wizard of Oz, right? I think the Terminator is
Princess Bride still works.
Princess Bride, okay. You should probably have some list of stuff that you can use. I think the Terminator probably still works. So I think like a lot of people have seen that movie, right? Well, to me, constitutional doctrine, if you're like trying to wrestle with it, is like the Terminator. And if you remember in the first movie when they capture John Connor or whatever, like he's come to like stop the Terminator, right? And he's in the police station. He starts yelling at them that they don't know what this thing is like, right? And he says, the Terminator is out there. It can't be bargained with. It can't be reasoned with. It doesn't feel guilt or remorse or fear, and it absolutely will not stop ever until you are dead. That's what constitutional doctrine is like. You can't stop it. And let me bring up some more serious points, so maybe we can have some general discussion. It seems to me that what has been happening in American culture and politics is that this sense of absurdity and emptiness about the enterprise of constitutional interpretation has been seeping through the culture and saturating it gradually over several decades. To the point where one could even say that the insights of critical legal studies, whether the Tushmantian version or the Nagelian version, have been internalized by the political process. It's politics all the way down, right? And the result of that is something like the Garland non-hearings, right? Which essentially consists of the Republicans saying, quite understandably, look, if it's politics all the way down, then the way we play the politics is you ask for this and we say no. End of story, right? In other words, if there's nothing else there, then it makes perfect sense for the Republicans to treat Garland's nomination like they would treat just any piece of legislation that's being proposed by the Obama administration, which is they won't pass it unless they have some overwhelming sort of pragmatic reason for doing so. Principles in some grand or general or edifying sense simply don't come into it. So where does this leave us? Well, I now will leave you with the following inspiring thought, and maybe we can have some general conversation. I think the problem, Bob's work lends itself to unhappiness, I think, because it's too intelligent, essentially. That's what the point of the inscription that he made to Allison is. And this brings to mind the French writer Flaubert's dictum. He said that for happiness, three things are necessary: good health, selfishness, and stupidity. And then he adds, but really without stupidity, all is lost.
said in the paper, it is you're in the doghouse with your dean when he asks you to teach constitutional law. There's nothing. There's no. I would. Although I know nothing about it anymore. It's been since law school but I'd love to teach wills. Because there's a there there.
Yeah, that's what you think.
maybe I would be disabused of that too. In which case, we really are in bad shape. But constitutional law is the hardest. There's very little you can do that is both honest and helpful. You can be dishonest and purport to be helpful, or at least students will think you're being helpful. Or you can be honest, in which case they say, we paid to get that. But that's, I concur with the general pessimism about the enterprise.
So I just like to say a couple of things, mostly about, provoked by Paul's comments, but ultimately about Bob as I think Paul's version was culturally conservative, critical legal theorist, which I think is right, but so am I, so it's okay. It's not a bad category to be in, from my point of view. First thing is that it's important for the intellectual enterprise to do the kind of critical analysis of the work of your political friends as much as it is to do the work, the critical work with respect to your political opponents. Because if you don't do that, and I have to say, we in the early CLS stuff did that. We were writing as much about Earl Warren and William Brennan as we were about, at that point, William Rehnquist and Warren Burger. Because if you don't do that, then what is left open is the possibility that your critical stuff is correct with respect to one segment of the political spectrum, but the other portion of the spectrum, they actually could be doing law, not politics. So what you need to do, and I think, as I say, we tried to do it, was to say, no, all across the spectrum, these kinds of problems arise. That's why at some level, taking Justice Kennedy as a target is just not the right thing to do. It's shooting fish in a barrel. Right? It's going after Justice Scalia in this audience, or Justice Kagan in maybe Justice Ginsburg in an ACS audience, doing the critical moves with respect to each of those in their political settings, in the settings where you expect sympathy for their political views. Now, I think it could be done. I think I've done some of it with respect to some people, but I do think that's the project. And the reason that I feel that an affinity to Bob's work is that I think he does that. So the implosion of American federalism, or the book on constitutional cultures, is as much about the political or the legal culture associated with, at the time of writing, political conservatives, as it was about the sort of New Deal liberalism.
I very much agree with that. I mean, as I said, I wasn't like picking on Kennedy in particular. I mean, he just happens to be more prominent because he's in a position to write these opinions. Again, I just want to emphasize, analyzing Supreme Court opinions as being intellectually interesting documents is a category mistake. Right? That's not what they are. They can be analyzed in all kinds of ways that are interesting, sociological phenomena, as a politics of various kinds. That's all very true, but we in the academy are sort of, this is the problem with the law school, basically, right? The law school is framed in such a way so that it's been handed what it thinks of its materials, so that those materials have to be treated as though they themselves were intellectually stimulating and powerful source of texts, right? I mean, again, it's sort of like, if you're treating like, you can do like occult studies of like the Kardashians, and it would be pretty interesting. But if you're like trying to analyze the Kardashians like it's Shakespeare, you're just making a huge category mistake. That's not what it is, right? And again, you get 1 out of 10,000 exceptions. I mean, I'm not so utterly cynical that I can't read like Robert Jackson's Descent and Karamazov and say, wow, that's really intellectually interesting and impressive and accurate, right? But the problem is that's like analyzing political rhetoric in the context of, say, campaign speeches by looking at like the Gettysburg Address and like Pericles' funeral oration, right? It's like 1 out of 10,000 of them are something like that, and the rest are like Donald Trump's speeches, It's kind of free association nonsense, basically. So I do think this comes back to the problem of what we're doing in legal academia right now, and this is very much exacerbated by the fact it's gotten so crazily expensive. All of us here, I can tell you, Mark, I have a particularly professional interest in this. I can tell you that in 1970, when Larry started teaching, tuition at Harvard Law School in 2016 inflation-adjusted dollars was $12,000 a year, which was, by the way, more than double what it was 15 years earlier in inflation-adjusted dollars, right? Today, Harvard is $62,000 a year. So if if the students are forking over $62,000 a year, they understandably are expecting something other than you need 2 witnesses to witness a will, or on the other side, the crit trashing, which is just like, okay, this is just a bunch of, this is nonsense too, right? Because that gets like boring pretty quickly, right? And people feel, well, I want something more to be there. I very much want there to be something more to be there, and I haven't solved for myself the conundrum of, well, what do you do now?
Can I open it up to
Absolutely.
politely listening, but please, question.
All right, so what is the answer to the problem if the rational basis test is too easily manipulated? What do you put in its place? How do you apply meaning to the 14th Amendment Equal Protection Clause? It's pretty important, isn't it?
I have a view which is quite controversial. I actually think that if you go to what I don't think is the right thing to do, which is to the original meaning of various parts of the Constitution, I think one would find, if you did this honestly, that the Constitution answers very few questions in today's world. It's a late 18th century and mid 19th century, the rights parts of it, a document that was dealing with some particular problem, and most of what the stuff that comes to under the guise of constitutional law that comes to the courts today is not meant to be answered by the Constitution. It's meant to be answered politically at some level, now. Sometimes the political process fails too, because in California, where I'm from, legislature it loves to come up with vague standards, and then the courts play with it. Say there are 10 factors you have to look at. So, it's a full employment bill for lawyers, is what it is, but it's completely manipulable. 10 factors, and how do you weigh them, and but it keeps attorneys busy, because nobody can figure out for themselves what's legally required or not. But my guess is that in terms of the real meaning of the Constitution, I don't do the kind of scholarship that you need to is that very few things that we deal with today violate it, and that the solution to whatever problems are raised are political solutions. And if they're political solutions, then one of the things, and Paul touched on this in the you see now, the more we recognize that the Supreme Court is just doing politics, it alters the way we think of the nomination of Supreme Court justices and what should be the process of confirming them. I want to know what their politics are. Not just whether they are well-educated lawyers and honest and so forth. Because if most of what their job, or at least the big things that they're going to do, are just political, then I want to know what their politics are. And if they're the wrong politics, from my standpoint, I don't want to confirm them, no matter how otherwise, how many credentials they might have. So, this is I think one of the costs of the I think avoidable politicization of constitutional doctrine. It may be that some parts of the Constitution are vague standards and there's no but general thing is that if it isn't, if you can't really say for sure that it's unconstitutional, then leave it alone, leave it to the political process.
Okay, one follow-up. Let's say in 1868, what was the rational basis for allowing men to vote and women not to vote?
I'm not sure what how to answer that. I don't know.
I think you've got to give some meaning to the Equal Protection Clause, and I'm sorry, I've got more faith in our Constitution than that.
Well, women couldn't vote in 1868.
Pardon me?
Well, women couldn't vote in 1868, so why do you have all this faith in this document that didn't give women the right to vote in 1868?
Well,
the
explain the
change
rational
there was
basis
not a
for denying it.
constitutional interpretation, but the is it the 19th Amendment, right? It's like that's like constitutional politics the old-fashioned way, which is you change it, right? So I think that's Larry's argument, right? That's how you that would be a sort of alternative.
Has our democracy failed in not utilizing the amendment process more so as to make the Constitution meaningful today? That's the process that was set up, and it does seem to me that if the judges can just say anything they want from a political point of view, it's meaningless. So, but the amendment process is not. So, what about the amendment process?
Well, the question is how much do you want to decide at the level of Constitution, at the level of supreme law that's entrenched? It's as opposed to leaving to the political process the decisions. This is one of the things. The American Constitution, I think, has been relatively successful just because it's fairly spare compared to lots of constitutions you find in the world, and it avoids affirmative rights, with the exception of the one that I'm most fond of because my wife's income comes from it, which is the right to appointed counsel and paid for by the state. Most of the rights in the Constitution are negative rights, and they don't require the court to decide what resource trade-offs have to.
So you're saying the language is meaningful.
The way it's been construed now. If the court starts finding, the decision that puts food on my table, which was Douglas versus California, which is dealt with the right of to appointed counsel on appeal in criminal cases. That's what my wife does. She does appellate defense in criminal cases. That was a pretty shaky-looking opinion. You go back and analyze it. So this sort of idea that you don't have a right to an appeal, but if the state gives you a right to appeal, then poor people have to be given attorneys. The kind of argumentation there is, I found questionable, as did I think Justice Harlan in dissent in that case. But notice that now is the court going to decide, well, you know, what's an attorney? Is anything that some state says, you know, you're eligible to practice law, does that count? It's not, surely not the dream team. And so they didn't equalize Rich and poor. They sort of said, okay, Rich can have the dream team, the poor can get, you know, whoever shows up in court. But the if the court starts deciding more, you know, if it starts finding in the Constitution all sorts of affirmative rights, which is quite possible, then the courts are going to be involved in things that courts in you know, Mark will know a lot more about this, in other countries that have constitutional rights to housing, employment, things of that sort. Then they're going to have to start making, you know, resource trade-offs. You know, how much do you put in education? What counts as a right to an education? You know?
So you think that's beyond their legitimate role?
I actually think the Constitution was not meant to, you know, that the rights that were there were basically immunities from government and not any kind of affirmative claim right. And you know, and those work fairly well. You know, they don't require.
I teach complex litigation and civil procedure, and until fairly recently, I would have said civil procedure has a fair amount of rationality to it and can be understood and is actually a coherent set of doctrines. I even was able to think that about complex litigation until about 10 years ago, and it took me longer than that to figure out that it really isn't rational anymore. And I have begun more and more sharing with students this dilemma that you've referred to, which is how can you give them their money's worth and admit that what you're teaching them doesn't really hold up to any kind of scrutiny. I've been groping toward since I plan to be around for another 500 years, appearances to the contrary notwithstanding, I want to come to a point where I can suggest some sort of rational scheme in which what courts are doing in complex cases could actually work, and I'm groping towards some idea of a coherent set of doctrinal limits on the roles of courts, and I wonder whether I have a feeling that Bob, in his career as a constitutional scholar, has been groping towards some kind of a coherent limitation on constitutional adjudication, and I wonder whether you have tried to do that. I think you have, and whether you think you've succeeded in finding ways to explain a more limited role for courts.
Well, I mean, I think that as a basic matter of political theory, if you have an institution of judicial review and a constitution which is difficult to amend, you are going to get a kind of common law of constitutional interpretation. That's, I think, inevitable. It's in the same way that, like, when we refer to the statute of frauds, we're not really talking about a statute, right? We're talking about a series of elaborated judicial doctrines, or similar things, say, in the context of antitrust law. When we refer to the Sherman Act, we're really talking about, you know, federal court doctrine about antitrust law, or, you know, Section 1983, or what, you know, any old statute that gets, you know, sort of elaborated over the years. And we have a culture, and Bob's work is very much about the culture of constitutional interpretation, which gives the federal courts, you know, this role in our, you know, in our political system. Now, whether that's a good or a bad thing, I think does not really have much to do with the reality of it. And here, I think, you know, Mark is right that one has to be very careful to avoid some sort of one-sided, you know, political critique that just says, "Oh, isn't it terrible that this justice over here did this?" With this kind of specious reasoning, when you could, you know, point to somebody else and, you know, from a different political orientation, you know, who's doing the same thing. So I'm very skeptical of the notion that, as a practical matter, one could even begin to imagine a significantly pared back and coherent kind of practice in terms of constitutional interpretation. Instead, I think it just has to be understood in the way that politics is understood, which is as a bunch of, you know, statute will have all kinds of incommensurabilities of one sort or another. And so that's that's where I think where we are and where we will continue to be. But luckily, I'm not a judge or will ever be one, and so I don't have to worry about that.
But you are.
Right, but I mean, I'm not, there's actually, it's funny. There's another Nagel, Thomas Nagel, the philosopher, who wrote an essay once called "What Is It Like to Be a Bat?" Right, where he was like asking the question, this kind of epistemological question of, how is it? Well, how does a bat perceive the world? Right, it's a very interesting and deep question. Well, I have the same question about like a judge. What is it like to be a judge? And I'm not the judge. I don't know. I have no idea. I can tell you what. If they had drafted me and forced me to take Allison's job, I just think as a matter of psychological and social reality, within a couple of years, I would be talking and walking and acting pretty much like a regular old judge. Right? That's the job, right? So that's not the job for me right now, and so I can just see it differently.
So can I say one thing about, in the sense of us as legal academics teaching students who are going to be lawyers? So my position on this is this. Suppose you are a lawyer of quality 30, okay? And you're making an argument in front of a judge of quality 20. So you're a better lawyer than the judge is. You're going to be able to lead that judge to experience the situation as one in which, I got to do what lawyer quality 30 says I have to do. The law tells me that this is what I have to do. Now, if you're a lawyer of quality 30 facing a judge of quality 40, you're in trouble. Because that judge is not going to feel the same kind of constraint from the law that you're able to present. So, what we need to do is to make our students, educate our students, so that they are more likely to be better than the judges, so that they're dealing with, so that they can make the judge feel constrained, even though, as an analytic matter, the judge is not constrained. I should say that is my experience, not cases, but with colleagues who, present arguments where they are at the 40 level and I'm at the 30 level. I walk out of the conversation feeling they have to be right, but I know sort of in my heart that can't be right, so it takes me another 4 or 5 hours to figure out where the problems were with what they said. That's what I want our students to be able to do that.
Just, go ahead.
I'm a relatively new attorney, and it was my experience that I learned more in my 6-week Barbary class about constitutional law, practical constitutional law, than I did in my 4-month, constitutional law in school. And my question is, so just as an example, like I learned more about the Erie Doctrine in a flashcard in my Barbary packet than I did in reading the actual case 5 times over. Why in law school do we continue to insist on teaching the law through reading these old cases to just get out that one little nugget that you can put on a flashcard? And why aren't more people trying to change the way we teach sort of practical law? These are the things you need to know to be a good lawyer. Why do we continue to insist on going back and reading these cases?
Let me quarrel a little bit with the premise there. What you learned was not constitutional law. What you learned was Barbary constitutional law, which may have very little resemblance.
Oh, I couldn't agree with you more. But it's practical in the sense that when somebody asks me about the Erie Doctrine, I have some knowledge about it, and these are sort of the things that you go through.
We can boil things down in a way that people feel they've got something they can answer a question at a party, and say, this is what.
I don't know what parties you go to.
It's a really boring life. But the problem is that so think this, you can take it with, as prejudice, but I think she's the best appellate, police criminal appellate lawyer in the state of California. It's a big state. But she's been on various judicial commissions, and one was coming up with, was reviewing criminal law instructions that judges give in criminal trials. And so I teach criminal law, so she would say, she'd give me some sample, and I'd say, that's just incoherent. She wanted to know how to make it. And I said, you can't make something coherent out of that. It's self-contradictory. And then her response to me is, well, that came from the California Supreme Court, and so I'm going to have to do that. And your statement is completely worthless to me, which is true. I mean, I was of no help at all. Not that I was wrong, it wasn't, but it just, she had to deal with the California Supreme Court, and you don't go before them and say, Your Honors, your test here is incoherent and self-contradictory. And so she can screen out the sort of what I can give her because it isn't useful for her. I couldn't do what she does. I couldn't play that role. Maybe I could have at an earlier stage in life, but I feel like I've bitten into the apple too much, and I couldn't make the kinds of arguments that the California Supreme Court wants me to make.
Let me suggest that one reason why, there's a couple reasons why things work in regard to your question. One is just social inertia. This has always been done, things have been done in a particular way, and just continue to be done in that way just because that's the way they've been done. People end up just replicating what they've been socialized to do. Law professors used to be law students, and that's where they learned to be law professors, essentially. Another reason, I hate to be blunt. Actually, I don't like to be blunt. Another reason is because it's easy. Because basically, you can take up a lot of time in class by using the case method to get people to sort of stumble around, first the facts of the case, and then the doctrine, and what's the holding, is that dicta, what have you. It's a lot easier to do that than it is to engage in a more sort of intellectually robust kind of inquiry. It just is. And human nature being what it is, and the sort of economies of scale of education being what they are, it's just cheaper and easier to structure legal education in that way. Now, look, are you familiar with the website Let Me Google That For You? You know this website? Well, I strongly recommend it to you. Essentially, somebody asks a question, you just type it into the website Let Me Google That For You, and then you click, and then it writes the question into Google, and then it hits click for you, and then the answer comes up. So what is the Erie Doctrine, right? You put that in, and then you click, and then it pulls up Google, and then it writes, what is the Erie Doctrine, and it's click, and then it'll get a description of the Erie Doctrine. Right?
Seems like there's an extra step there that you could avoid.
Well, yes, but I believe there is, but I think the point of the website actually is to sort of be mean to your friends when they ask a dumb question, like what time does the game start? Let me Google that for you, right? One of the many problems facing legal education right now is that in the world of let me Google that for you, you've got to have something more interesting to do and say than talk about what the Erie Doctrine is in terms of what can be put on a flashcard. Because, if you're doing the Barbary version of law, then the way we're doing it is just like the most massively inefficient and wasteful kind of possible way of doing it.
Melissa, do you want to stop at 10:15?
I think if there's maybe one more question.
One more question.
I was just curious, this gentleman, well, follow him as well, but he was mentioning about the woman's right to vote and what have you, and not thought that was kind of interesting, but I'm just wondering this, it seemed like after the Civil War, a lot of the changes to the Constitution, this gentleman was talking about amendments, a lot of it, came out of war, amendments to the Constitution. And obviously now we've had a lot going on with the Patriot Act and whatnot and 9/11. Do you see, I just wonder, what kind of spin do you see wars putting on this subject of this conversation?
The last part, what?
How do you see wars putting a spin on this conversation?
Well, one way of addressing that is to observe that many forms of that constitutional development of various sorts is intimately connected to developments in the political system. Some of those developments are occasioned by war, others are occasioned by economic crisis, the New Deal, and so on, or the Great Recession or whatever we're calling 2008. And it's not surprising that you see that the Constitution becomes different because its development is mediated through politics. And that's going to be true more or less across the board, I think.
We're done. All right. It is wonderful, actually, to see so many hands up at a Rothgerber conference. So that is terrific. Please, I'm sure our speakers are willing to stick around, but let's give them a big hand.
We're going to have a quick break and we'll reconvene at 10:30 for the second panel.
It seems like, as well as being a response to
That's the answer. And I was actually 19, so I think I feel like we had a lot more practice. More practical and sitting there with them, like, they have a question for me and I need to quickly come up with an answer. I rely way more on my reflection when I go down there. And it's like, like I said, I have some